Good afternoon, everyone. Allison Scoburg here, Consolidated Planning Group. We are here today with Gigit Tyler and Carly Mader with the Tyler and Maderer law firm, and we are going to be talking more about important decisions that you need to make to protect your child with special needs. Consolidated Planning Group is a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy. We are an advisory and consulting firm. We are not attorneys. There's a lot of confusion often on what we do and what a law firm does. And I always kind of shorten that up and say that you guys are the paper and we're the money. So how much do we need to fund that special needs trust? You guys help set up things in special needs trust and wills and guardianship, and we're going to be talking about some of those things today. But when you're planning for a loved one with special needs, the truth is that you need both sides of the coin here when it comes to planning the finances and the money, and having the money in the right buckets, and of course having your legal documents in place as well. We help people set up protection plans, lifetime care plans. We do a lot of transition planning. We help set up ABLE accounts, and we do a lot of advocacy through these webinars and our podcast. So if you're joining us for the first time, we are glad that you're here. Welcome. And if you've attended our webinars in the past or our podcast, we are glad you're back. From a housekeeping perspective, we are in webinar mode today, and that means that we can't see you or hear you, but we do know you're there. We're glad you're here, and we hope that you'll put your questions in the chat box. We're going to get to as many questions as we can within the hour that we have together today. So having said that, I am going to turn everything over to both Gidget and Carly, and thank you again for joining us. It's certainly our pleasure to have you back. You guys have a lot of great information, and so we're happy to hear what you have to say today.
Yes, thank you, Allison. We're glad to be back. And Tyler and Maderer, as Allison mentioned, we are a full-service disability law firm. We help people with estate planning, specializing in special needs trusts, and guardianship, probate. We also help clients get on Social Security and walk them through that program, SSI and SSDI. And yeah, I mean, we're here to help. And this webinar, as Allison said, is about guardianship. And the three things that we're going to, go over, I'm going to speak a little bit first, and then Gidget will take it over. But basically, does my child need it? I know that for a lot of parents, guardianship can be a very confusing and emotional process. So I'm going to kind of help you walk through that. We're also going to discuss alternatives to guardianship, which is actually required in Texas. Under law, you need to at least look at the alternatives and make sure the alternatives, aren't something that is applicable with your child. And then we'll go through the actual guardianship process, like what the legalities involved. So I got into special needs planning because I have a child with some intellectual disabilities and physical disabilities. And at 18, based on all the research I could possibly do for her syndrome, she will need guardianship when she turns 18. And I know this based on, again, a lot of research and just kind of my knowledge of her syndrome and what she can and can't do when she turns 18. Because, according to, Texas law, you do not have a legal capacity to enter into any type of contract or agreement or legal document until you're 18. When you're 18, you're an adult, and unless proven otherwise, you have the legal capacity to enter into a contract or some of these agreements that we'll discuss. So that is why that it is important if you have a disabled child, and especially like in my case, someone that will be intellectually disabled at 18, you need to, go through, do I need a guardianship? Is guardianship appropriate for my child? Or can we go through some of the alternatives to guardianship? So here are just some helpful questions to ask. I think this is helpful for parents to just have on a slide. And if you're deciding whether to, go through the guardianship process, and again, we'll go through what that looks like. I kind of go through some of these scenarios with clients. So can my child live alone? Can my child learn to drive? does my child need help with handling money? So for example, just from an intellectual, standpoint, if my child was handling their own money at 18, if they gave someone $10, would they know that they need $5 back? Or could they possibly get taken advantage of the fact that they might not understand that? And then, would my child be able to vote in a presidential election? Would they understand kind of the ins and outs of voting, right? Because you have to be alone to do that. Would my child consent to surgery if it was recommended by his or her doctor? What about a blood draw? What about dentist work? If it's really needed, would my child understand at 18 that this is in their best interest, or will they just say no and refuse all treatment? And then does my child understand the legality of marriage? That's something that we've seen kind of an issue with, where an intellectually disabled person was married and then their benefits were terminated. Also, if someone explains, so I try to walk through this with some of my parents. If I were to explain a power of attorney, and we'll get into what that means, or support a decision-making document, would your child understand what I'm telling them? Because they have to have that capacity to enter into these agreements. So, walking through some of these questions with your child is even helpful if they're verbal and they understand what you're saying, but also just asking yourself, because you know your child best and you know your child's capabilities when they turn 18. So with those questions, kind of helpful there. There's a lot others that we'll go through to kind of decide, but we also explain alternatives to guardianship. Every time we meet with a client, we definitely go through these first, and I'm going to have Gigit go through some of them.
Right. So again, my name is Gigit Tyler, and the four documents that we're going to go over is the supported decision-making, the durable power of attorney, the medical power of attorney, the HIPAA, and the declaration for mental health treatment. And I will say, everyone, before we even get into this, if someone is over the age of 18, they should always have a durable power of attorney and medical power of attorney and a HIPAA. If they're not disabled, they need that. Every 18-year-old needs it, because I've had some really sad situations with an 18-year-old who wasn't disabled, and they get into a car accident, and of course they didn't have any of these documents, and their only option is a guardianship at that point. Had they done it at 18, we could have avoided the guardianship procedures. So first, we're going to go into what is a durable power of attorney. So the way I normally explain it is, this is the business decisions of your life, right? So this allows someone to do stuff with your bank account, pay your bills, talk to other legal entities like financial institutions, Social Security, things like that, that you're not taking power away from your child, so your child can do these things with you, but it gives you access to all the business aspects of their life. And so this is a really important one, that if you have this, this does negate a lot of the things that you need for guardianship, because they get to talk to your bank, which we'll go over some drawbacks in a minute, and they get to, call your attorney's office. Like, they can call us. Like, I have a lot of clients where their parents already have power of attorney, so I'm dealing mainly with the parents, not the child, as long as I have that document signed, because they had mental capacity to do it. Now, the child is the one who's giving you power. So sometimes I'll have people call and say, well, I'm going to get guardianship over my child. At that point, though, it's really the child who's my client. I've got to sit down and talk with them. They get to elect who they want their power of attorney to be, and they're actually going to sign the document giving you those powers. Then we're going to go to the next slide. Kind of the drawbacks, things that we talk about with people as far as a durable power of attorney. Some financial institutions are really particular, and they won't accept it. They have their own forms. What I always recommend to all of my clients is, once you get your power of attorney completed, take it to your bank and say, hey, are you going to accept this form? This is the person I've nominated for my power of attorney. So if they have any issues at all, then we can get that fixed and get it on their specific form. Also, the problem is again, you're not taking power away. So if you just have power of attorney over your child and they decide they want to go get married, someone's taking advantage of them, this doesn't stop that from happening. They can still sign their own contracts. They can open their own bank accounts. They're fully functional. This is just giving you the power to do it also. Also, they can revoke it. So if they get mad at you, as they get older, let's say they have some, oppositional defiance type disorders, they can get mad at you and say, I revoke this, and then you no longer can go in and help with those things.
We have a couple of questions, but the first thing that I wanted to ask first is, can you talk about what the drawback or the real issue is? Where, we've seen some families that probably really likely needed a guardianship. The individual did not have the capacity to sign the power of attorney in which they signed. Can you talk to us about the problem of having this document in place when actually guardianship was probably the most appropriate?
Well, the first thing is if anyone were to, let's say, a contract, this is essentially a contract, right? It's only as good as, someone's willing to enforce it. But someone could go against whoever had them sign the document saying, hey, they didn't have legal capacity to do this to begin with, and therefore we're not going to accept it. And really you're violating probably some fiduciary duties by, using that knowing that they don't have the power to sign. And we actually come across that a lot. Like families will call us. Obviously, guardianship is a longer process, it's more expensive, and they kind of get upset when we won't do it for them if we see that they don't have mental capacity because of that, because it's actually not valid. And so let's say you go do a real estate transaction. I've had that happen where they had a power of attorney, but somehow the title company found out that there really wasn't capacity there because of a dementia diagnosis. And they needed letters from doctors saying, yes, they do have mental capacity. Of course, none of the doctors would sign it. So they went through all that, and the real estate transaction failed because the title company was looking and saying, hey, this person really doesn't have mental capacity. I don't even feel good about accepting it. You really want to be careful. And that's a big part of what we do. We sit down and talk to our clients. If it's what we call a gray case in the middle, we're going to side on, okay, it probably needs to be a guardianship because I don't want this person signing something they should be signing.
And that is one thing that you said in the beginning, that you guys are really sitting down, you're getting to know the individual and understand for yourself what their capacity is and those types of things. Because I think, as you mentioned, it is an emotional process. And a lot of times people feel, sometimes they feel nervous about meeting with a law firm because they don't really know what they need, and they feel like they should just walk into your office and know what they need. And I always like to encourage people that you don't have to know what you need. You just need to know that you need to work with a professional, and they're going to walk you through this process. And we've seen in a medical setting where the healthcare power of attorney was rejected because they said that the individual never ever had capacity. And so that's where we have seen that be problematic. So we have just a couple of quick questions that I'll run by you. And if you want to table any of them, you can. Just to mention, yes, this webinar is being recorded today. Everybody's going to get a link to the recording and a copy of today's slides. And it will also live on the Consolidated Planning Group YouTube channel after the fact, so you can hear it later. One question is what is the right of survivorship on your home? Do I need this for my 18-year-old son? Like, I guess they're asking, like, what would happen if a person dies? Would the house go to the child, or what would need to happen?
Yeah, it's kind of hard to answer that question without a little bit more context, only because if the 18-year-old son is disabled or has a guardianship, the guardian would essentially manage any property left to the son, right? But there's a lot of layers to this too. Do you want your son, if your son's receiving SSI or Medicaid, do you want your son to have right of survivorship of your home? Yes and no. It's like case by case. One of our talks before, when we did a webinar on SSI, is that you can inherit a home and own a home as long as you live in the home and you're receiving SSI. So again, that we might have to, as a general answer, I think I've answered it, but for more specifics on their situation, we would just kind of have to go through why they're asking this, and if it's right to do some type of right of survivorship for your home, to your son or to your disabled child, or if it's better to leave it through a trust or something like that.
And we've seen both, and I just want to remind folks that when an individual is getting SSI, they can have one house, and one car. And as you mentioned, sometimes we see that the house is left to a special needs trust, basically to prevent bad actors from trying to take advantage of an individual with a disability, trying to take the house out from under them. So there's a lot of different doors a person can go through for this. This next question, this is a great question. And I know we were just at the National Special Needs Planning Conference this past week, and this question came up, and I don't have an answer, but maybe you guys do. So the question is so if a person's guardian dies and the parent was receiving the maximum Social Security, but that amount exceeds the Medicaid waiver income limit, which is 300% of SSI so that's $28.29 per month, would that person lose their Medicaid? And again, that was the chump question of the week last week at that conference, and I don't have an answer. Do you guys have any insight on that one?
Well, first of all, there's a lot of different, it says Medicaid waiver, and there
So-
are lots of different Medicaid waiver programs. But I will say in a general, and if they're just on Medicaid, let's say that the child was on SSI and getting Medicaid, if they're adult disabled child, disabled before the age of 22, they will keep Medicaid and get Medicare. But specifically, as far as a Medicaid waiver program, I'm not sure. We would have to read what that specific waivers requirements are. And unfortunately, there's quite a few of different
Yeah, I'm gonna dig deeper on that too. I know that the Texas waiver income limits is 300% of SSI. So if SSI for 2024 is 943, that 300% brings it to 28.29 per month. But yes, we will dig deeper on that question. That is a great question. So thank you for that.
Okay, so one of the other documents that's really important to have, everyone should have this one again, but also another way to, have an alternative to guardianship is the medical power of attorney. And this is who gets to make your medical decisions if you can't make them, right? So the thing about this is it only happens if you're incapacitated. So like, let's say you're in surgery for one thing and they go in there and they discover something else and they need, hey, can we do surgery on this other organ, or if you're in a car accident and it's an emergency situation, that's what this document is for. So it is, if the person cannot make decisions, this allows you to make decisions for them. However, if they're awake and you're in the doctor's office, they still get to make the decision. So this really only helps, I would say, more in an emergency situation, like a coma or something drastic helping before this is gonna come up. And again, it can always be revoked. So if they get mad at you and they no longer want you to make the medical decisions, they can revoke it. And unfortunately, there isn't anything you can really do about that. But this is a really important document that everyone should have as long as they have capacity to sign the document. And then the next one we're going to go over is the Declaration for Mental Health Treatment. This is another one that can be really helpful. I would say, if you have a child with mental health issues, let's say something like schizophrenia or bipolar disorder, where it's kind of up and down, but it only comes into play again if they're incapacitated. If the doctor doesn't think they're incapacitated at the moment, they still get to make the decisions. But let's say they are schizophrenic and they're in a really bad psychosis type state where they're hallucinating and out of touch reality. This gives you the ability to consent to things like the convulsive treatments, certain medications, and they can go through and make it very specific. So they can say, I will consent to these medications, or they can consent to all medications. They can even put on there certain medications they wouldn't want, and allows you to get emergency mental health treatment for your child if they need it in that moment. But again, it's only if it is decided by the court or the doctor that they're incapacitated at that moment. But it can be very helpful in certain circumstances. All right, and then this is another one everyone should have. This just allows you to get access to the medical records. Anyone, for all of our clients, if you put someone on a medical power of attorney, you should also back it up with this form, because we have had situations where a hospital did something bad and they didn't want to release the medical records to the attorneys, even though someone had a medical power of attorney. They're like, well, that doesn't give you access to the medical records. So we just do this as an extra layer. We want those medical records. We want to see what's going on if we're going to make decisions for anyone. So it's a really important document, but again, they have to have the capacity to sign to give you that ability to view their medical records. This is a really important document. This is the supportive decision-making agreement. And I really like this document because it's you and your child working together and you're saying, hey, I'm giving you autonomy. At the end of the day, you're going to make decisions, but I'm going to help you get the information you need to make those decisions. And it just, to me, it feels better sometimes than just the power of attorney, because it goes through about getting food and clothing and getting education. Like you can give this to school so you can get the information you need. So you can give it to them so they can still make the decisions, but you're helping them make, you're getting the information, you're working together as a team. I like this as the team document. I feel like it's less threatening sometimes when you're explaining it to your child. You're saying, hey, you get to make the decisions, but I'm just going to help you do those. And so this is another one that we would recommend someone having with their child if, they have disabilities, but maybe they're not to the point where they need guardianship.
And Gidget, some states, I know that we have listeners sometimes from out of state. It is important to note specifically for your state if there is a supported decision-making agreement. It's not a thing in all 50 states, so you do want to check your state on that, but it is definitely a thing in Texas.
Yes, agreed. And not just like like a thing in Texas, the courts actually really encourage it. Which is great. The courts in Texas, they don't want to, well, they would rather not, right, grant guardianship if a person can truly, just with the help of supportive decision making, make decisions on their own. So, it's not like guardianship is this bad thing. It's hard to talk to parents about it sometimes because there's been such negative, negative media on it, even, I always say with the Britney Spears thing, if people have heard about that, yeah, that was a nightmare, right? And it got a lot of media, but, guardianship is really supposed to be an important and necessary thing when a person becomes incapacitated, right? And I think that that's where it's hardest for most parents that are like tuning into you, Allison, because, maybe their child is not 18 yet, but they know that they're intellectually disabled. They've had some struggles or just developmentally disabled, and they're just unsure. So, it's beginning to be 15, 16 years old. They're still not quite there. I don't know if they're going to understand all of these things. What do I do? And so that is where it is important to come to us and kind of talk through what guardianship is. Talk to someone, even like me, like an attorney who also has a child that I'm gonna have to do the exact same thing when she turns 18. Or talk to Gidget, who's, dealt with disabled clients for so many years, for 15 plus years, that can kind of, not that we're experts, we're not doctors, and we'll go through, what we recommend first and foremost for guardianship, but, just to at least talk to people that have seen it, that have been through the process with clients and have seen children who reach 18 that are not ready to sign these alternative to guardianship documents. And I always like to give the example, with our elderly patients, elderly clients, right? If they come in and, they're with a friend or a family member that, is trying to force them to give, that family member or that friend power of attorney, we have to be very cautious of exactly what they're understanding. So we, make them leave. We talk to the elderly client one-on-one, and we have to make sure that what we're telling them and what they're telling us is valid, they have the capacity, they understand what they're signing. So it's the same type of thing. I mean, we're under an ethical duty to monitor that, and we take it very seriously. So now we're turning to, what is guardianship and just the process. So,
Can we pause just for a second? Because before we move on to guardianship, someone asked, how does a supported decision-making agreement help in a formal way? And then we do have a few questions on guardianship as well, but if you want to answer the supported decision-making agreement one first.
Yeah, supported decision-making is just, it's becoming so well used and well known in Texas that especially educational settings, they see it and they're able to talk to the parents with the child and understand that they're making exactly what it says, supported decisions. Where, this child is, maybe has some delays, mental delays or mental disabilities, or some type of even developmental disabilities, yet they're understanding and they're making decisions and they're excited about making their own decisions, but they absolutely want the help of their parents. So it's a really good, in a formal setting, I'm trying to think of what another formal setting would be, but like schools is a perfect example. Even what we said with healthcare decisions, right? Medical power of attorney does not come into place until you're incapacitated. You cannot consent for yourself. But this supported decision making, well, let's talk about this. Can you, talk to the dentist about this, procedure? I'm going to be sitting here and helping you make the decision, with you, so that the dentist can hear that you've consented or not consented, right? So it's kind of, all working together. And I a formal, setting would definitely be a healthcare, in the healthcare setting or educational. So, I think that answers the question.
Yeah, and I would say we would never recommend just to have that. We would always have a power of attorney with it. So you want
For
both.
sure.
Because the power of attorney does have a little bit more teeth to it, I feel like, than the supportive decision making.
There's someone that asked if they could have it for a 17-year-old, a supported decision-making agreement. And quite honestly, it's just not even necessary because you have those rights over your minor child, and it's once they turn 18. So the two other questions before we move on, regarding guardianship, it's basically guardianship and divorce. Like, what if we, as co-parents, we agree that a guardianship is required, but we don't agree on the specifics? For example, they're separated and co-parenting, and they each create guardianship paperwork with different guardians. And then the other question is a similar theme, only can I specifically exclude somebody from having the ability to ever be a guardian? For instance, an absent father that has been out of the picture for 18 years. Those are the two major questions, and then we'll come back to questions later.
Okay, so first let me tackle the first one. Can you declare, so let's just the basics of, can you declare guardianship for your child? Well, you definitely can and should for a minor child, right? So if your child's a minor right now, in our state plan, we do declaration of guardian. And that states, who would be the best guardian if the parents were to pass away. Now, the court is likely going to grant guardianship of any child, whether it's an adult disabled child that needs guardianship or, minor, to the biological or adopted parent, the guardian at the time. Now, again, but it is up to the court, right? It's in the best interest of the child. They're going to first kind of default to the parent. If that parent truly has been, completely, absent, right, from the child's life, and, due to some either child custody paperwork or divorce, they've even given up some rights, then no, they're not gonna, it's gonna be hard for them to get guardianship over that person at whatever age. But yes, I always say, definitely in your declaration, put who you absolutely do not want as guardian. Absolutely, especially if you're granted guardian as a parent, and now you are guardian and you can make decisions for your child, you can have them have a declaration of guardian that, these, and you as a parent as well, these are the people that I would want to be guardian in my absence, in my incapacity, or in my death. And these are the people I absolutely would never recommend, right? Because they're either, they've never been involved in the child's life, or they're a convicted felon. A convicted felon, likely the court would not allow them to be guardian. But, if they've ever stolen funds or they're just not trustworthy, yes, definitely put people down that you don't want. So I hope I answered that question. And then the first one was about co-guardianship. Is that right?
Yeah, I think it's this one.
Okay.
So they're separated. So you have to be married to be co-guardians. And no, you can't file two separate ones. The court's going to pick up on that really quick, even if in a different state. Like, we had someone try to file a new guardianship and they already had one in Florida. The court's going to cut that off really fast. There will only be one guardian. And if they're competing over who that should be, at the end of the day, the court will take evidence and decide which parent they want to be the guardian.
Okay, and so in when you have a guardian, so in some states, I just want to mention some states do offer co-guardians for non-spouses. It just depends on what state you are and what those rules are and things. Um, in the example, I know in a guardianship, typically there is a successor guardian. So if I'm guardian and I pass away, then there might be a successor guardian named. Is there always a successor guardian named? And if you need to update this or you need to be co-guardian with your spouse and it wasn't set up that way, what is the process for getting that done?
Here you go.
In our application for guardianship, there is no successor guardian,
Not in Texas.
not in Texas. So it would be, I mean, someone would have to be reappointed if someone passes away.
Now, I think what you're saying is when we're doing like estate planning, you put who you would want to be the successor guardian, but the court, you're still going to file documents in court to get that switch. It's not going to just naturally switch in Texas.
Right. Because the guardianship, I mean, especially, we're just gonna go through guardianship of the person, but guardianship of the person, I mean, this is the court, right? The court is granting guardianship. This is a court process. So this is nothing like, it's very different from like a medical power of attorney, supported decision-making, durable power of attorney, where these two people are coming together and creating essentially a contract or legal document. This is all court supervised. But for your co-guardianship, the co-guardians would succeed to the other. Absolutely. They can just become just the sole guardian if someone were to pass away.
Okay, so if a person, like they're a married couple and say mom has legal guardianship of the disabled adult child, but mom isn't well, but they're still married, so could dad be a co-guardian and they would just need to work with an attorney to get that straightened out?
If they're married, they can be co-guardians.
Yes.
Or just, well, they don't have to be, but you can be in the application. But yeah, if you have any kind, that's what's hard about this. It is very fact sensitive, right? So that's why it's really important to speak to an attorney and say what's going on so we can kind of tell you this is the best. And it is state. I'm glad you keep bringing it up because we're talking about Texas. We cannot advise anyone on any other state because this is specifically state law for guardianship.
And also I mean, each year the court requires you to file, like updated estate, documents or updated information about the ward, right? Because I mean, they want to make sure that each year they're granting the correct person as guardian, and the person is still considered incapacitated. I mean, I think so many people think guardianship is this permanent thing forever. Well, absolutely not. I mean, especially with medicines and therapies and all the wonderful things that are happening in the medical community for some of these rare diseases, your incapacitation can actually be lifted. I mean, according to a medical professional, which we'll get into that, if you're no longer incapacitated, then absolutely you do not need guardianship, and you shouldn't have guardianship. So there's a checks and balances there, and there should be.
One person said, if you are awarded guardianship in another state and move to Texas, do you have to transfer that guardianship?
Yes, you do. You have to file an application in Texas. You have to go through the background check. You have to do a lot of the steps. The difference is you don't have to, which we're going to go through the process, but you don't have to get a new attorney ad litem, a guardian ad litem. They would still hire an attorney ad litem just to look at it, but it is a little bit faster, but yes, you have to get it switched over to Texas. And it's really important that you do it very timely.
And isn't it true that if you move counties that you need to get it updated or something if you change counties in Texas?
In Texas, yeah, there is, if you're going from county to county, that's what's hard too. It's not even state law, but you have to start looking at the specific county and how rules are as far as how difficult that is. It could be just filing the papers there, or it could be a new actual application for transfer, like what you have to do out of state.
Okay, not to keep going down this highway, but I think we have more questions on this. Two more questions on this co-guardian. So how many co-guardians can you put on the original guardianship?
Only ever two, because you have to be the married parents to be co-guardian in Texas.
Okay, and then someone said, when did that rule that was set that there's no more successor guardian? So there can't be a successor guardian in your paperwork. You can't name somebody else as successor.
You can name it in your estate planning, but the court names one person. So, if you want to have a successor, you put that in there, but it's still, the court has to monitor it. So you're always gonna have to file something with the court. It doesn't mean they're not gonna accept it, but you can't just switch the paperwork, on your own. Because if that person, for example, let's say, I have Carly as a successor for me, and let's say I'm, 10 years down the road, now I've passed away, but in that 10 years, she's been convicted of a child crime. That's why they have to monitor it, because they have to safeguard this person. They have to make sure they haven't, done anything illegal. They haven't, did something against a child. They do make them do a new background check, even from state to state. Like I said, this person, I have clients where they already have guardianship. When they come to Texas, Texas will not just accept that person. They redo the background information, because their job is to protect the disabled person. So that's why it's not that you can't have, there will be a successor. I just can't say with 100%, the person you name will be it, because they have to make sure that person's fit. It's a big responsibility.
It's not automatic. And I even say that for people that are doing a declaration of guardian. Yes, this is going to give a lot of weight to the court's decision, but ultimately it's the judges, the court's decision, what's in the best interest of the child. So if they've named, people that, I don't know, live in Africa now and are, and then there's a sibling right down the street, the court might look at that and say, okay, hold on. Do we really want to uproot these children? Their parents have now died and have them move to Africa? Or should we go down the line, right, to maybe their third alternate, which is right down the street? Because, things change. Every year could be different. So that's why it's very important that the court is involved, because nothing can be just automatic through the guardianship process.
Okay, two more quick questions. If you have guardianship and you're planning on moving out of state, do you have to get permission from the court to move the ward out of state?
No, I don't need to get permission, but if you want to go ahead and start speaking to an attorney in that state to get it transferred, to see what the rules are for transfer. Because when you do that you do that yearly, then they're gonna say, oh, you don't live here anymore, right? And it's gonna become an issue. So as soon as you move, I would go ahead and work with the new attorney in the new state to get it transferred over.
Okay, if you passed away, you have your daughter as successor guardian for your disabled child. She has to go to court to get a new guardianship. It's basically a question confirming that she would have to go to court to get the new guardianship.
It's not necessarily a new guardianship, but you have to file paperwork to get who the guardian is. So she would want to go speak to an attorney, yes, and have everything transferred over to her. But it's not, when you say a new guardianship, it's not like you have to start the process completely over, like proving the person needs a guardianship, getting the new medical paperwork. It's more making sure that the new guardian is fit for duty. So it's not starting over. It's just, there is a court process to it.
So, and because of the court process, some people are in the chat box asking, like, if the guardian dies, if the guardian passes away, like, what is that timeline of getting that other guardian appointed? So if the person doesn't have capacity and it's a couple of months down the road, or like, what could a person expect? Or is a death a crisis and they move this along quickly? How does that work?
Yeah, and there's also temporary orders you can get from court.
Emergency, yeah.
Yeah, there's emergency temporary orders you can get. And again, that's going to depend on not only the state, but the county and what even judge you get. In Harris County, we have 4 different courts, right? Like everyone has a different docket and how long it takes to get things through. But when there's an emergency situation, it will move faster.
Can you tell everybody, and then we're going to pause on questions just for a little while, but feel free to put them in the chat box. If you have a child that is turning 18, when is the best time to engage an attorney on the guardianship process to start the process so it's in place in time?
17, right?
Yep, I would say 17. When they turn 17, shortly thereafter, go speak to an attorney. And we'll go through the process. We'll go through the questions, all of that will determine if alternatives, which is required. That's one of the second steps. The first step also is this certificate of medical examination. And before I file an application, I have to have that. And it has to be completed by a doctor within 120 days of me filing the application. So it is some time, there are some time limits and time restraints that we talk through. but your first initial appointment, should I get guardianship? What does that look like? What are some dates I need to keep in mind shortly after they turn 17, because it can take 9, 10, 10 months, sorry, 9 or 10 months. We haven't seen it take longer than a year or a year. But at least knowing that, 9 to 10 months, you should obviously start when the kid, turns 17. At least understanding, what all the steps are going to be and the time frame. Are we moving on or more questions?
Yep, we're ready. Thank you.
Okay. So the guardianship, and I think we've said this, but I kind of want to go back to the other slide, and just to get it fully out there, it is, the court is giving a responsible person, the person that should be guardian, full or partial decision-making power, authority. There is, with like a partial guardianship you can get in Texas for an incapacitated adult, and that incapacitated adult is called the ward, in Texas, so that the guardian can protect and look after them. If the person that is receiving guardianship also needs guardianship of the estate, that's a little different. But the court is involved in that as well, and there's a lot of documentation that needs to be sent to the court. And the court also states that the adult is incapacitated. And I like to, tell parents, don't take this term to heart, right? I mean, your child is wonderful and can do so many things. So don't think that because they're considered incapacitated, it's almost like they're not even a person. No, that's not true at all. Guardianship can be such a beautiful thing, that you're helping this child through life because of their, developmental disability or their intellectual incapacity. So it does not define your child. Your child can still live a very fulfilling life. It's almost like how I like to look at it is what I'm doing right now for my 7-year-old and what any parent would do for their 7-year-old. You're just needing to do that for the rest of your life. It's almost a blessing for me, right? I can monitor what she does and support her throughout her life, because honestly, in my case, my daughter will not become intellectually fully developed past the 8-year-old capacity. So, and maybe that'll change, but as of right now, that's kind of what we're seeing with people and adults with her syndrome. So that's another thing I like to tell parents: look at if you do have a diagnosis, look at some children with the same diagnosis or similar. Of course, everything's a spectrum, but look to see, like in my situation, my daughter Kennedy's, her syndrome, none of the adults right now are considered or have the capacity to have a guardian, to not have a guardian, excuse me. So all of them have guardians. So it's nice to do some research like that to, again, make you more comfortable with going forward in the process. And then this is the process. So what I just mentioned, the certificate of medical examination. If you're unsure, if you as a parent are kind of like, we're in the gray area, my child is high functioning autism. We hear that, those words a lot, and verbal, and they can understand so much. But I just don't know if, legally they can enter into this contract. I'm just not sure. This is a gray area. Should I get guardianship or not? Go to your physician. They have the medical background to consider someone incapacitated or not. So that's a very, very big first step. And also it's what the court relies heavily on, is what is in that medical examination. So definitely get that done. And then we also have to prove that we spoke about alternatives to guardian. That will be in the application. And that those, medical power of attorney and support decision-making agreement that Gigit went through, they just aren't adequate for the level of support that this child needs. And then we file the application. You also, as the proposed guardian, you are our client. The client that we're talking to is the person wanting to get guardianship over their child. The proposed guardian does have to complete a guardianship certification. And for some parents that seems silly, but it's important, right? I mean, guardianship is a court process. And like Gigit mentioned, you have to prove that you are fit and that you are able to be a guardian. They don't know that you've been the best parent forever for 18 years. The court has to see that, you've passed this certification and you are able to move forward with the guardianship process. And then the judge assigns an attorney ad litem. That is, the attorney ad litem is supposed to represent the child, right? So we are representing the clients we represent are the parents wanting to get guardianship. This attorney is appointed by the court, and it is going to represent the child and make sure that the child is truly incapacitated and does need these support services. The attorney also will talk to the child at the child's verbal, and they will explain what guardianship is. A lot of the times they'll, review medical records, they'll talk to schools, and other caregivers or other family members. And then the ad litem writes a report for the judge. This is also, excuse me, this is also, the judge weighs heavily on the report from the ad litem. And then if your child owns more than if your child has less than $2,000 in assets, I think actually that's like 3,000. But you can also forego the need for a guardian of the estate, excuse me. So that's another thing to keep in mind.
Tell us really quick about serving. I think sometimes people feel overwhelmed because I think like a sheriff or somebody comes out to the house, they get served. Tell us about that part.
Excuse me, I'm like,
Yeah, I'll take over. Sorry, she's having, I think the allergies are bad today. So the disabled child does have to be served. And so, that is normally the sheriff or the constable. You can also hire outside companies. But we try to communicate when that's going to happen with you as much notice as we get. And, it's really just, they hand them the paper. They're not going to come and be scary or be mean to them or anything like that, but they do physically have to be served.
Yes, and there is also, we've been able to alleviate some of the anxiety from that by telling them it will be within this week.
Yeah.
So we try to do that for clients as well.
And on the asset, can you confirm 2,000 or 3,000? I know that the magic number for SSI is 2,000. If it's an adult, with a disability, the magic number is 2,000, but I don't know about for guardianship. I don't know that number.
Let me look.
Okay, we'll come back to.
Yeah.
That's okay. No problem.
Okay, so then when you go through the process of guardianship, and then kind of what we've already talked about, once it's granted, there is a renewal every year by filing a report with the court, and we can help you do this, or you can honestly do it on your own. We've had clients do it on their own. But again, the court needs to be kept up each year. So that's what we were talking about how it's never just automatic, right? For a successor guardianship, it can't be, because you do have to file this report. And the court wants to make sure that the ward is still incapacitated. Not a full-blown guardianship each year. So I think some people get nervous about that. No, you don't have to prove that you're a good guardianship each year. You just have to keep the court updated by filing this annual report. Yeah, there is a bond. The court may require you file a guardianship bond or fee every year. They decide the amount of this fee when making the guardianship decision. So that is set by the court. That's not something Gigit and I control, and it's not something that is in our fees, right? We don't put that into our flat fee. And then kind of what I mentioned earlier, if your child shows new capabilities or starts to show that they need extra support or protection. If you've gotten a partial guardianship before, you can ask the court to modify guardianship. You can also request the court to terminate guardianship. So again, this isn't and now I have guardianship, or now my child has guardianship and she can never have rights again, or he can never have rights again. That I hope that kind of mentality around guardianship goes away, because one of the biggest things Gigit and I learned from judges themselves is they kind of like to modify guardianship, especially if they're granting more rights to a ward, or if they're terminating it altogether because the person is now 25 and able to finally understand more and live alone and take care of themselves. So that's something to keep in mind when you're first, even thinking about the guardianship process.
I know this question always comes up, and so forgive me, but can you give us just an average range? You don't have to give your fees, but can you give an average price range for guardianship? And if there's a family that may have lesser means or can't afford guardianship, are there places where families can get financial aid or help with guardianship?
Yeah, I mean, there's definitely legal aid. There's also nonprofits that are set up for this very reason, especially if guardianship is more of a emergency that's needed, right? You can definitely reach out to those nonprofits for the disability advocates. And then, but for Gidget and I mean, yeah, I mean, a guardianship is 3,000 around there. There are some extra fees as far as paying the ad litem and things like that. But you're looking at around that. I mean, there's some attorneys that charge 5,000, 4,000. It also depends on, does the children have a lot of assets and they need guardianship of the estate? Like Allison, I mean, I think you would agree too. We would probably lean more towards getting a supplemental needs trust, especially if there's public benefits involved. But yeah, I mean, I think that it could vary, but I think that's the range you're looking at. And then, request, again, if you can show that, you're struggling to pay those fees, there's payment plans and things that you can do.
Thank you.
Okay, so the next few slides is honestly just a real life example, and it kind of goes through, and I don't have to read this unless you want me to. We can answer more questions. But this is basically wrapping up our talk, in that it was a very good outcome. Navigate Life Texas had this story, and I thought it showed a lot of the kind of shows a lot of the questions people had about co-guardianship and about divorce, and then also just about John is the word, overall well-being, when guardianship was just the absolute right decision for this family. So do you want me to go through it, or do you just want to?
Yeah, let's go ahead and hit the highlights, because we have people that listen on podcasts. Anybody that's listening on podcasts and they want a copy of these slides, you can email us at contact@cpgcares.net, contact@cpgcares.net, and we'll be happy to send you the slides. But yeah, let's hit the highlights and then we'll hit a few more questions.
Okay, so John was or is this is a real life example. I mean, we've changed all the names to protect privacy, but John was going to need someone to help manage certain things for him, but he also could do a lot for himself. But talking to doctors and insurance companies, that kind of overwhelmed him. And the parents looked into guardianship. And so they looked into it, but they also wanted him to have as much of the decision-making power as he could and as he could manage. So they ended up asking the court to give them, 3 areas of guardianship over John, and that was housing, school, and medical decisions. They also had to decide who would be John's guardian, and the father and the mother were divorced. And so they couldn't share guardianship, as Gidget mentioned, in Texas. So between the 2 parents, it was kind of a tough decision. But in the end, it was John's father that agreed that he would apply for guardianship when John turned 18. I could go to the next slide. And so John hired the attorney and he filled out all the necessary paperwork for them. The whole process took about 4 months, which is great. It means the courts were running pretty quickly. And then they talked a lot to John about guardianship. So even before they began the process, the parents sat down and told him that he would always have someone there for him and to always help him. And he really wanted that. So when they explained that this was, something that could be put into place that would, fulfill and have a more fulfilling life and make sure that he wasn't anxious about certain things, he really liked that. They also talked to him about the attorney ad litem, that someone else besides them were going to talk to him about all these different areas of decision-making power. They said that the ad litem interviewed John about 3 times and looked over his medical history and talked to his school. He also asked John questions to make sure that John wanted the guardianship, because that's another thing that the ad litem will look into, right? I mean, what if there was someone trying to get guardianship of a person and they truly did not want that person to be guardian? The ad litem is going to take that into consideration. It won't be the end all be all. I mean, it's not like your child can say, absolutely not, I don't want my mom because she didn't fix me pancakes this morning. It's nothing like that. It's something like, no, they really though want to talk to the ward and make sure that this ward feels comfortable with this guardian, especially if it's not a family member, right? Going into that successor guardianship as well, that the court really looks into this through the ad litem. And they rely heavily on the ad litem's recommendation. So even though it was emotionally hard to ask a court to assign the guardian to their son, John's guardianship hearing was a positive experience overall. The judge agreed with everything in their petition. So everything in their application that they wanted to have support over John, they granted. And so it was a good experience for not only the parents, but John as well. And if you go to the next slide, when John turned 21, he graduated from school and he was going to need to continue the support. So again, each year they looked into, can John, can we lift this guardianship or not? At that point, the mother was living in the same city as John and his father. And then at that time, John's father realized it was probably best for the mother to now take over guardianship. So they ended up switching, which again, is such an important thing to look at each year. And that's why you have a report and you have a kind of a, let's figure out the best interest of John each year and who that guardianship should be. So having John under a partial guardianship has all worked out for everyone. He still gets to decide who his roommates are, whether he wants to go to secondary school and what type of job he might have. So again, one of the things that was really important to John and that the ad litem discovered too, was that his job was very important and he wanted to make the decision on what job he had. And the court agreed with that. And even though that the mother does not have financial guardianship, John hasn't been interested in managing that part of his life on his own. So she's been able to work with the bank and manage his finances without any trouble with alternatives to guardianship. So that's something that was positive as well for them. And I mean, I'll just read the rest, but it takes time and resources to go through the guardianship process, but every year an investigator from the court comes to make sure John is being taken care of. She fills out a guardianship report each year and she sends it into the court. I love doing that job because I include lots of pictures to show how happy John is with his life. John is 27 years old now, living with roommates in a house that I manage, the mother manages, and he likes having me as his guardian, knowing that I am looking out for him. I sleep better at night knowing that I have the legal tools in place to make sure his needs are met. So I just loved this real life example. It's a positive experience. And she kind of goes through everything that her John and John's father went through.
That's an awesome story, and I am glad that you went through it. So thank you for that, and I'm sure our podcasters thank you for that as well. So going back to the question on kind of the average fees, first I wanted to mention for the people that say that they cannot afford guardianship, there's disability rights. If you type in free guardianship in your county or legal aid in your county, those places are going to rise to the top. So as opposed to us giving you a list, each county has some different legal aid places, but if you type that name in, it's going to come up. You can also contact the court in those counties. They'll be familiar with the legal aid programs in their county as well, but I know disability rights. The other thing that I want to mention, the only county that comes to mind is that Galveston County has a grant and they have free guardianship, but you have to live in Galveston County. And there's another county in Texas, and I don't know what it is, and it's not right around like the greater Houston area that I'm aware of. But sometimes there's, endowments or grants or other things like that that may make the process free. And that's the only place I know for sure is Galveston County, but you definitely do have to live there.
Yeah.
So this is definitely a process, as you said, and it can be an emotional process, and there's always these, these one-off, there's such things as contested guardianship, which we hope you don't have. But it is possible in those adversarial divorce situations that, you know, it could be a contested guardianship. But on average, so like a range, so if somebody's trying to plan financially, how much money should they plan to set aside to have a non-contested guardianship, just a range?
3 to 5.
Yeah, 3 to 5,000, depending on the attorney you speak to.
Yeah,
And
that's kind of
can I
what I was
answer a
thinking.
couple of these questions just because
Yes.
I feel bad that I didn't state this, but if you are getting guardianship over your adult child that just turned 18, you do not need the HIPAA and durable power of attorney, medical power of attorney. You have full guardianship once granted. So so that is something that, you know, you can alleviate that. The issue is though, if you're in that kind of gray area and you're starting down the guardianship process, you still may want to, if they're turning 18, you know, right away, you still may want to get some supportive decision-making or something, talk to an attorney, see if they do have some capacity to sign an agreement or to allow you to access some things. Because it's going to be really hard if you've waited and now they're 18 and you're now kind of shut off from certain things that a doctor or a financial institution will allow you to gain access to.
Gidget and Carly, I know that we're out of time for today, but you guys are taking new clients. People can schedule a consultation with you to talk further. You know, they can help if you're having matters with the Social Security Administration and denials and appeals and things like that. I know you guys can help that way, but you can also help review other special needs trusts or other documents that they may already have in place, help set up new documents, have these discussions, deeper discussions regarding guardianship and their unique situation. So the best way to reach out to you guys is by email. Is that correct?
Yeah, those emails are great. You can also call us. We should have put our number as well. But 832-761-7773, Google Tyler and Maderer. Our website has all that information as well. You can even shoot us something on like a chat through our website.
Sounds like a plan. Well, guys, it has been a pleasure being back with you. It's always, and I have to say, we had some wonderful questions today in the chat box. So thank you, everyone that joined us today and put your questions out there. Your questions help somebody else. We always offer free personalized consultations. So should you need to take your planning journey to the next level, reach out to us. We'll meet you kind of where you are in the planning that you've done so far. This QR code will take you straight to a calendar where you can book a free initial consultation. Again, this has been recorded. Everyone is going to get a copy of today's slides and a link to the recording. It'll also live on the Consolidated Planning Group YouTube channel after the fact. And again, if you've joined us by podcast today, you can just email us at contact@cpgcares.net and we will be happy to provide you a copy of the slides. Thanks so much, everyone. I hope everybody has a great day. Take care.
Bye. Thank you.
Bye now.